Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
The U.S. Supreme Court has decided to hear an important case regarding prayers at public assemblies. This case will be argued in the fall of 2013 and a decision coming down sometime in early 2014. I am Matt Staver, founder and chairman of Liberty Counsel. Joining me today is Shawn Akers, Vice President of Liberty Counsel's Middle Eastern Affairs, and we're going to talk about this important case involving the town of Greece in New York, a small town that had a lawsuit against it because of prayers before the local government meetings. And the Court of Appeals ultimately ruled against the town, saying that the prayers were predominantly said by Christians or had Christian words, and therefore a reasonable observer, using Supreme Court language from a previous case, would assume that this is an endorsement of religion and therefore unconstitutional. The Supreme Court decided to take the case. It's a good sign that they've taken the case. Of course, we just don't know which way they'll rule. Yeah, well, at least they have taken it, so we'll have a chance to have a say in court on it. But, Matt, you know, you and I have talked about this so many times in the past that in this case it looks like kind of gearing the opposition. It's literally saying at the appellate level that if the requisite number of people happen to be Christian, if the majority happen to be Christian, then that alone makes this illegal. But the implication of that is if they weren't, if they were anything else, if they were Muslim or if they were Wiccan or if they were atheist or if they were whatever, then it would be fine. But again, it's anathema if you happen to paint it with the Christian moniker. Well, in fact, that's what I think this Court of Appeals essentially did. It's conflicting with two other courts of appeals because in 2013 there's been several courts of appeals that have come down on this issue. The 11th Circuit Court of Appeals, which is in the southeastern part of the country, has upheld prayers at public assemblies like this before, say, local city or county commissions or councils. And the Ninth Circuit Court of Appeals, which is on the West Coast, California and Oregon and Washington, those surrounding states there, also came out with a decision that upheld the same kind of prayers. And in that case, the argument was, well, the majority of these prayers were said by Christians, and therefore it makes it Christian endorsement of religion. The Court of Appeals for the Ninth Circuit said, no, it doesn't. It's permissible. This court, however, in the New York area that governs the northeastern part, said, yes, it does make it Christian. So there was a conflict among the different circuit courts of appeal, and that made it a classic case for the Supreme Court to take. Now, the last time the Supreme Court took a public prayer case was the Marsh versus Chambers case, and that was a case out of, I believe, Nebraska, where the legislature had a chaplain that opened the legislative sessions with prayer. And the Supreme Court at that time said it doesn't violate the Establishment Clause of the First Amendment because they looked at history. The founders, actually, who drafted the First Amendment, also authorized a paid chaplain to open up the federal legislators every day for every session. And how could they draft the First Amendment and then do something the same day that was contrary to it? And so consequently, prayer had predated the First Amendment. It was endorsed by those who actually drafted and sponsored the First Amendment. You know, Matt, that's such an important point, and it's one that I hope our listeners really, really get. If something has changed, we know that, because at the founding of the nation, you didn't have these kind of suits being brought. It wasn't an issue at all. So if the Constitution said the same thing then that it does now, and the people were praying then, and it didn't bother any of the founders who drafted the Constitution, then something's happened. And what I would hold out to you is that we're seeing, when we talk about this living Constitution, when we talk about relative morality, even though the Constitution hasn't changed, we've got a group of people that have systematically fought to change what the Constitution means, to change the Constitution right under our feet, so that that which was good in the beginning is now considered bad, and that which was bad in the beginning is now considered good. No founder would have ever questioned. They would have thought you were a lunatic if you tried to challenge opening Congress with prayer under the First Amendment of the United States. Yeah, for some of the founders to suggest that you had to monitor the prayer and censor it of any content, particularly religious or Christian content, in order to make it constitutional, or to have no prayer at all, they would have absolutely picked up arms and fought. I mean, they fought for religious freedom, and they didn't think that an acknowledgement of God, whether it's from a prayer at a legislative session or in our public buildings or documents, violated the constitutional First Amendment Establishment Clause. What's ultimately happened is over time the courts have skewed the interpretation and gone away from the original intent. And so now we have these courts that are split, saying that this is an endorsement of religion. You know, I say that if you look back at this particular practice, if it's an establishment of religion, it hasn't been a very good establishment of religion because it's gone on for many years.
That's right.
And there's no single religion that's established. And history, I think, is a good indicator. But again, it's another part of this cultural war where they want to undermine the religious values and the foundations and the moral absolutes on which this country is founded.
You know, Matt, you have to ask yourself, which would really be the more effective establishment of religion? The government staying out of it and allowing individuals to pray as they see fit, or the government becoming involved to the extent that it wants to monitor exactly what's being said in a prayer, where the government has to pass muster on the content of a prayer. Now, that sounds to me like the government establishing an acceptable form of religion and is exactly 180 degrees off of what the founders sought to protect us from with the First Amendment.
That's exactly right. I mean, you know, Justice Joseph Story, one of the early justices of the United States Supreme Court, he said that the First Amendment was to be something that would encourage religion, and Christianity specifically, he said, so long as it was not incompatible with the rights of conscience. So it was intended to encourage Christianity, not to prostrate it to everything else, obviously not to force people to pay tithes to a particular church, or certainly not to establish a national church. But this kind of thing was not even considered an establishment of religion. So I'm encouraged that the Supreme Court has taken the case. Obviously, we don't know which way it'll go. When it's the right time, Liberty Counsel will file an amicus brief in support of this important case. And, you know, one of the things that I hope the Supreme Court does is not only rule in favor of this practice of prayer before the lower court, before the lower governing bodies, whether it's school board or city or county council, these lower government, local government bodies. But also I hope that they do away with what's called the so-called Lemon Test. That's a Supreme Court decision that has caused a lot of confusion. There's as many interpretations one way as there are the other way, and I would hope that they go back to more of an original understanding of the First Amendment.
You know, Matt, ironically named, you know, when we buy a car that's not exactly what we hoped that it would be, we call it a lemon. Well, I think that really applies with the lemon test as well. You're one of the most experienced attorneys in the United States on this particular issue. Matt, as elected officials, especially the lower level elected officials, school boards, city councils, and those type things, face the opportunity to either implicate these issues or not in their own practices, what advice would you give them?
Well, first of all, I think they ought to call Liberty Counsel regarding this. But in terms of the prayers at the government bodies at the local level, I would say that they not tell people that the prayers have to be non-proselytizing, non-sectarian. When you do that, if you say you can pray but it has to be non-proselytizing, non-sectarian, what are you saying? It's got to be a secular poem. It can't be
That's
proselytizing,
right.
which means persuasive. It can't be sectarian, which means Our Father who art in heaven. Although some ACLU people I've debated said, well, that's non-sectarian. Well, it could be considered sectarian as well. The problem with requiring a prayer to have a certain aspect is the government has to inject itself into the content. The government shouldn't tell people how to pray or what to pray and endorse certain prayers over another. They ought to allow people to pray as they see fit. So they could either have a member of the staff pray, or a member of the elected body, or they can do what a lot of people do, a lot of councils, and they invite clergy from the local community to say a prayer, and they just let them say whatever they want to open that individual session. Well, go to Liberty Counsel's website. We have information on public prayer or prayer at public assemblies. We have that in the book, Eternal Vigilance, and we also have it in other pamphlets and brochures as well on the website at lc.org, and you can get more information by calling 1-800-671-1776. That's 800-671-1776. 1776. Also, I would encourage you to get the book, The New England Primer. It's a little pocket-sized book, and when someone talks to you about church and state, show them this book, because this was a little book that was used in American public schools for nearly 200 plus years. And it has both Bible as well as the alphabet all together. That was never considered a violation of church and state. That's the book, The New England Primer. For a contribution of only $7, we'll send it to you right away.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.